Hello, I'm a California criminal defense attorney. The preponderance, the majority of my cases are related to sex crimes. It is an area of focus that I long ago ventured into because it really is terrifying the degree to which all it takes really is a set of unfortunate circumstances, a perfect storm, if you will, involving an unscrupulous, dishonest accuser, and it can devolve into a nightmare for guys, primarily, obviously, right? So, and what I'm referring to is accusations of rape, sexual assault. In my experience, representing people accused of these crimes, I really have been alarmed the degree to which there is, in virtually or in the supermajority of cases, really no corroborating physical, biological, scientific evidence. It is almost always a situation where there is some sort of sexual encounter or romantic sexual liaison, and the female party will indicate later on, or whether it's out of regret or familiar pressure, or whatever the case may be, that it was not a consensual act. Okay, and so obviously that has tremendously destructive consequences for a human being. It's really it doesn't really bring me any. It's very saddening to say this because I am fully aware, just by virtue of my proximity to the whole criminal justice system and the institutions, the correctional institutions, by virtue of my being a criminal defense attorney. But in some ways, prison is really the tip of the iceberg. In some ways, it's really, I don't want to say it's the least of a defendant's worries, because it's certainly, I don't want to downplay the nightmare that must be. But what I'm trying to say is that when a person is accused and ultimately convicted of a sex crime, prison isn't the end of the road of punishment, right? So for people who are, even convicted of violent offenses, egregious, severe crimes where sex is not a component, largely prison, and then whatever parole might be left after that, is pretty much the end, after they go through the incarceration process. Whereas for a person who is convicted, and imagine, wrongfully convicted, what the tragedy that entails. So somebody who is wrongfully convicted, goes through the incarceration process, is let out on parole or finishes his term of incarceration, and then is required in California, as of 2020, is required to register as a sex offender for the rest of his or her life. The exposure online, not just Megan's Law. There are many, many websites that traffic in the publication of mugshots and very probing, invasive information of people. And obviously that has very, very far-reaching repercussions all the way to the end of the convicted person's life. So the stakes couldn't possibly be higher than when or if you are accused of a sex crime, and we're going to talk about rape specifically, how those cases evolve. If you are convicted, if you're currently being suspected of having committed a sex crime, you need to pay attention to what I'm going to say, okay? This could be life-saving information. It isn't legal advice. Don't go around later saying that you relied on this or any of my materials online or in any format or source. This is merely the state of the law, but what I am going to put the emphasis on is on the defenses. It's important to understand, especially if you don't have the opportunity to contract a private defense attorney because you've been, you're ultimately incarcerated or what have you. Obviously, the optimal situation is you want private defense counsel who's going to have the resources. For example, my office, it's a team effort. You're going to, we use it, to the degree or where it's appropriate, investigators, legal researchers. It's really a team effort. Imagine you are going up the weight of the district attorney's office with a budget in the seven figures easily each year. They have massive resources to destroy your life. So you have to, you have to position yourself in a way that it's going to be a fair fight. Okay, so let's go ahead and get started. So under Penal Code Section 261, here are the elements of the crime. Okay, we're going to get into the defenses in a little bit, but we really can't address the defenses until you understand how you can be convicted. Okay, so the way that the law in California defines rape is as follows. There must have been sexual intercourse, obviously, with the victim, the complaining witness. Now, this is a delicate area. I'm just reading what the current element of the offense is for this particular crime, but the parties were not married at the time. Okay, so that's one of the elements of the crime currently. That could change later, but under the penal code I'm referencing, 261, that's one of the elements. The other person did not consent. We're going to come back to consent. Consent is the linchpin of these criminal cases and convictions. And the accused party accomplished the act by using either force, violence, duress, menace, fear of bodily injury, retribution, and or fraud. Okay, so let's go ahead. Now, I really want to hone in on the consent element because that's in a great proportion of the inquiries I get from young men, middle age, what have you. Most of these accusations that I've seen, at least currently, they're happening because of people go on these dating apps. Okay, I don't want to specify which one in particular. There's one that you probably have in mind because that's the one that's the most spoken about, but there are several. And so generally what I've seen is, we get a call and it's from a guy usually, and they'll tell me something to the effect of that they met somebody online or whatever. That ultimately doesn't matter. And that they had sexual intercourse. And here's where the terror strikes, okay? So in the subsequent hours, days, weeks, months, sometimes years, they get a call or a text or some communication where the female, the victim, the complaining party completely denies having issued any sort of consent, expresses not only regret, but and just a communication that is conveying that my prospective client really had no right to penetrate this person, have any sort of sexual contact, liaison, touching, etc. Okay, and so understandably, people are terrified because that's a very that is the first and one of the most important steps in the direction of a criminal indictment, okay, and the hell that comes with. And the problem in these cases is that the prosecutor, they have the trump card, and the trump card, the ace up their sleeve, as it were, is this Penal Code 290 lifetime sex offender registration. So effectively, it's a very slick maneuver. They offer, in many cases, even probation or a quote unquote low level of incarceration, meaning just a very contracted period of jail or prison, followed by lifetime sex offender registration, as opposed to, the ultimatum is always, if they don't play ball, if they don't cooperate, you don't plead, then it becomes a situation where you could be penalized for the maximum possible sentence a jury, a court can impose. It is a felony crime in California, rape 261, Penal Code 261. It's punishable per count. This is just per count. So that means it could be even more than this if the penalty is consecutive, okay? 8 years in state prison. So if it's 2 counts, you're looking at 16 years, and then exponentially from there. So obviously the stakes are very high. And of course, obviously the lifetime sex offender registration component, which is a ruiner and a destroyer of lives. Okay, so let's get to how to defend against something like this, because really the worst place you can be, the worst dynamic, and this is what makes defending these cases so challenging, is the issue of he said, she said. That goes back and forth forever, and then ultimately it's going to be up to the jury. It's an enormous gamble to take if you go take this to trial and they end up believing the complaining party. You're shit out of luck. That's just how it is. And you could be innocent all day long. And that is unfortunately the truth. The adversarial nature of the criminal justice system in the United States is really, there's no overt requirement that it has to be corroborated by specimen or any, a rape kit even necessarily. That obviously helps the prosecutor, but there are many people that are put away just on the strength of a credible sounding allegation, and then it's lights out. It's very sad. That's how a lot of that's how you have a tremendous amount historically, a certain proportion anyway, the convictions are just wrongful by virtue of the fact that it's not that hard to convict somebody of a crime of that magnitude. Okay, so the problem with consent, the problem with arguing that the other person has consent is it's a factual issue. It's how do you prove something like that? How do you prove when the female is saying that she didn't consent to it? Most of the time you don't sit there and sign a contract with the other person or get their consent on tape, or that's so unromantic, or some of these sexual liaisons, these encounters, they happen so spur of the moment. It's just unrealistic to expect people are going to do that. I don't think I've ever heard of that in any of my caseload where people do that. Obviously that would be compelling evidence of consent, but it's just not something that happens really often. And so again, it's back to he said, she said. So the way that consent works out is that obviously that's the one thing that if it's missing, forget it. Okay, you have the prosecutor has a convictable case. To consent, the female, again, this is right. This is traditionally how it plays out. The male is the one who gets prosecuted for these things in almost every circumstance. To consent, the person must have acted voluntarily, freely, and must have known of the nature of the act. We're going to get to that also. Okay, so here's how consent works in terms of the timing, because a guy can begin a sexual encounter with a person, the other person, the female, and she could change her mind in the middle of the act. Then what do? You can't just rely on the fact that, so if you continue beyond that point, when she says, stop, don't go further, the encounter might have started with consent, but once that expression is made, it's over, and the guy must have stopped. If not, if he continues forward from that point, it's rape. So continuing on here. So if the sexual act is committed without consent and the complaining witness communicates no consent, a reasonable person would have understood that communication meant that there was no consent, and the defendant, the guy who's accused, forcibly continues to act on that intercourse, then obviously there's no consent, okay? It isn't required that the victim have fought back or resisted in order to convey a lack of consent, okay? It just needs to be verbal, even if the person is arguably still having sex, but if it's without, if it has happened, if it continues to happen after that verbal expression, then, you're going to have a problem. You're going to have a very big problem convincing a jury otherwise, okay? And so now it's critical to start identifying the potential defenses, okay? Because unfortunately, if you're accused of this sort of thing, the only thing you're going to be able to rely upon, absent what I'm about to tell you, the only thing you're going to be able to rely upon is your own testimony. I mean, it's rare that defendants testify at trial. Most of the times, attorneys advise against it. I would imagine that there are acquittals that happen with that being an element, but very rarely, because of the fact that if you're accused of this crime, you want to opt there, you go up there and you being forthful, forthcoming and honest, but prosecutors are very well versed in cross-examining you, so that your credibility could become impeached, and then you're going to have a jury disbelieve you or not believe the other party simply because the prosecutor is very well trained in and can use your words against you in ways you can't even possibly imagine. And you thought that you were testifying in a way that you're going to convince the jury, and you're being completely honest and truthful and still get convicted. It happens, okay? There are better ways to accomplish that. There are better ways to try to get a case dismissed than to go through trial. It's always my philosophy, generally speaking, that we want to accomplish as close to an acquittal as possible. So as close to or the same thing as we'd get in a jury trial, but you want to take the risk element out. It's too risky. You're going to go in front of a jury, put on a great case, and then for factors that completely unbeknownst to you, they don't like you, the way you look, whatever the reason might be, that may have nothing to do with guilt or innocence. The stakes are too high. The best thing to do is to muster up the defense well in advance, extremely well in advance. And that takes investigators. You must have experts. You cannot rely. It's extremely rare that your attorney is just going to be able to rely on. I don't care how good your attorney is. It comes down to the facts. The facts. How do you put the prosecutor in a position where they understand that they're going to lose the case? That's not going to happen unless you are able to muster up objective evidence that the accuser is lying, that she's making it up. So an investigator is going to be key. Piecing it together, trying to find what is her motivation, what is her bias. Has she been convicted of any crime involving moral turpitude, involving dishonesty that can impeach her credibility? Because you got to do that before. You can't wait for trial for something like that to happen and hope there's some miracle your lawyer is going to, decouple her testimony and like magic. It's just that's all Hollywood bullshit. Doesn't work that way. These cases, winning these cases is a marathon, not a sprint, and it takes effort from the beginning. It's a continuous thing. It doesn't happen like it does in Hollywood, guys. No. And so let's get into how what the most powerful defenses are. We've talked about consent. Now, the consent element, there's the other side of it. Your side of it is that you were possessed of a reasonable and actual belief. But again, that's going into he said, she said territory. There are better ways to attack it. There needs to be some evidence of it. Okay, so that could be a series of communications, especially if they're in writing. And then before this person communicates that she changed her mind, you have something in writing. You can show a pattern of consent Uh, I'm not going to get into the rape shield laws and all that. This is strictly between you and the person who is making the accusation. Okay. Um, a less a less common defense, at least in my experience, is that there is another one about that what you and this person engaged in didn't constitute sexual intercourse. I'm not going to get really that into it because we're for purposes of this video, we're assuming it happened. Okay. So when it comes to unveiling the false allegation, it's going to be critical to look into this person's past. I'm not talking about how many guys she slept with and all of that, but I am talking about what motivation she might have had. Okay. What was it? Is it jealousy? Is it vengeance? Is it anger? Do you guys have a child in common? Is she trying to leverage a conviction, your conviction for purposes of custody? And really, that's going to take heavy duty investigation. Okay. At my office, we're big on that. Okay. You must uncover that. And any of this, the I didn't do it approach is played out. It doesn't work unless it is extremely backed up by factual, by investigative and substantiated evidence of consent. Okay. So ultimately that's what I'm trying to communicate to you. Just if you take anything away from this video, is that since what you're trying to do is essentially prove a negative, that it didn't play out the way that the accuser is saying, you simply cannot rely on holding steadfast with the I didn't do it defense unless it's going to be backed up with evidence of bias, with some sort of pretext that this person is making it up. Other witnesses also who might have seen you guys, maybe if it's like on a date, obviously they're probably not going to be seeing you during the sexual encounter, but they might have seen you after the fact. But, people see you sort of together getting along. It would be unlikely that this person, after you engage in sexual intercourse with her, she's going to continue to have a friendly relationship. And then later on, she does a complete U-turn and she changed her mind. So that's the other thing. The critical thing also is time and space. The more time has gone by after the allegation has been made, and the interceding events also. So any amicable relationship you and she had, that's going to be critical evidence of consent. At least that's what I would argue. So, okay, be safe out there. It's a very dangerous world to be dating, and it's going to continue to get more dangerous as well with the social pressures. This is not a political video, but we have to acknowledge, for example, the Me Too movement, as well intended as it may have been, there were probably unscrupulous people with their own agenda who were using it to bring people down. If you're accused or someone you know is accused, give us a call. Go to lawyerinmyarea.com. California Criminal Defense. I'm specifically talking about sex crimes, okay? The stakes are too high. Don't think it's just an accusation like that is going to fizzle out on its own. You need to have an attorney way before this devolves into a criminal indictment, because not having that representation before the arraignment, you are wasting precious time that can make all the difference in the world between living a prison-free registry life as opposed to going to prison and then being a sex offender. You never want that for yourself, okay? Be safe.